Okay. Well, good morning, everyone. My name is Eric Evelyn, benefits consultant and founder of the Evelyn Group. Thank you all for joining us this morning for the State of the State update with Frank Kerbein. Now, we have a ton of great topics that we're going to cover today. But to start off, please note a couple things. You'll notice all mics have been muted and the cameras have been turned off. Throughout the webinar, if you have any questions, feel free to input them into the Q&A button at the bottom of your screen. And then what we'll do is we'll address as many as we can at the end of the presentation. Okay, so before we dive into the State of the State updates, I wanted to take a moment to recognize our sponsor, the Business Council of New York, and share why they're such a valuable resource for employers across New York State. The Business Council is the state's leading business advocacy organization, representing more than 3,200 employers of every size and industry. Their membership spans everything from Fortune 500 companies to family-owned businesses and sole proprietors. Collectively, Business Council members employ over 1.2 million New Yorkers, giving the organization incredible reach and influence when it comes to shaping the policies that affect businesses every day. What truly sets the Business Council apart is the strength of their experienced, trusted staff. They have a team of more than 40 policy and business experts, widely regarded as among the best in the state. Their team works hand in hand with members, not just at a high level, but collaboratively and constructively, to help employers navigate legislation, regulations, and compliance challenges. And because of that expertise, the Business Council has built exceptionally strong relationships with state leaders. Their president, Heather C., along with their government affairs team, works directly with top officials in the Hochul administration, the state legislature, and key regulatory agencies. They have a seat at the table on influential task forces and advisory bodies on issues ranging from childcare and economic development to fiscal policy and infrastructure. In other words, when major decisions are being made in Albany, the Business Council isn't just watching, they are involved. For members, that influence translates into meaningful advocacy on the issues that impact your bottom line: workforce development, labor and employment regulations, economic development incentives, and the overall cost of doing business in New York. Members also receive direct support on legislative and regulatory matters, plus timely insights that help you stay compliant and competitive. Beyond advocacy, the Business Council offers exceptional networking and educational opportunities through events held throughout the year. These bring together leaders from across the state to learn, connect, and promote their businesses. And finally, membership gives businesses access to cost savings programs, competitive group insurance, employee benefit programs, and discounts on essentials such as shipping, office supplies, travel, payroll, and HR services. For many employers, the savings alone can be more than enough to cover the cost of the membership. At the end of the day, the Business Council provides something no individual business can achieve on its own: a unified, powerful voice fighting for a better business environment in New York State. If you're looking for advocacy, resources, influence, savings, or community, I strongly encourage you to consider membership. It's one of the most impactful partnerships a New York employer can have. And that brings us to our speaker today, Frank Kerbein. Frank serves as the director of the Center for Human Resources at the Business Council of New York. In his role, he leads the Business Council's advocacy on labor and HR issues, unemployment insurance, and workers' compensation. And he also provides hands-on HR consulting to member organizations. Frank brings a wealth of experience to the table. Before joining the Business Council, he held a variety of HR leadership roles in both financial services and healthcare. He's a graduate of Cornell University's School of Industrial and Labor Relations and has spent more than 35 years working in human resource management. He's a certified senior professional in human resources, a certified association executive, and a frequent speaker on HR topics across New York State and nationally. We're excited to have him here with us today. Thank you for joining us this morning, Frank. We really appreciate it. Please take it away.
All right, glad to be here. Thanks, Eric. That's a great description of the business council. Did we write that, or did you come up with that yourself?
I came
Because
up with that, so
that
thank you.
I'm
I
gonna have to
appreciate
use
that.
that.
Yeah, it's all yours.
Um, well, thanks. As we'll get started, as Eric mentioned, I'm part of the business council. We're the state chamber of commerce. I'm part of the government affairs team. We have of the staff that Eric mentioned, we have 7 lobbyists at the Business Council who are have areas of expertise. I do human resource, labor, workers' comp, unemployment insurance, and in addition, I provide HR consulting services to our members. 70% of our members have fewer than 50 employees and may not have a dedicated HR professional on staff, and I can sort of fill that role and help with compliance questions. I get this 800 number on the screen you see is our HR hotline, and I answer calls all day from our members about various HR challenges they might have. I'm going to talk today about what's happening in New York State, what makes New York State unique. We'll talk about the legislative process, what's new and coming up to help you comply with what the state legislature is doing and give you some inkling as to what's coming in 2026 and beyond. As I mentioned, I'm part of the government affairs team. So by nature, we are political, right? We advocate on behalf of our members. We're trying to create good jobs, strong communities across New York State. And with the legislature we have in New York, that can sometimes be challenging. So my conversation will be a little bit political. So I beg your pardon on that right away. And also, I tend to be a little cynical sometimes, and that might seep through in my discussion. I'll apologize in advance for that as well. I'm not an attorney. We do not give legal advice on these webinars. There will be times when you need labor counsel. I'll mention that during the program in light of what's coming down the road in the future. I'm an HR guy. I've been doing it a long time. I'll have to update my bio. I had my 40th class reunion, so now I have 40 years of experience doing human resources. So I give HR answers. You know, it'll be a little different than what you might hear from your legal counsel, but bear with me, you'll get the point. So, what is the New York State legislative process? For those of you fortunate enough to live outside the 30-mile bubble around Albany and don't live this day to day, you may not be aware of how our New York State legislature works. And I want to give you some background on that. We have a part-time legislature. They meet January through June. They are in session now. There will be 63 days of session activity for them. They anticipate finishing by June 6th. Though they're part-time, they're the highest paid legislature in the country. And they're very busy. They're very prolific. They introduce and pass more bills than any other legislature in the country. In 2025, during the legislative session, more than 16,500 bills were introduced. We're in this time of the year now where they're back in Albany. They're in their, I guess, third week of session now. Every night we get a report, our intros report, we call them bills that are introduced, and there'll be 300-400 bills a night. We go through those at the Business Council, the 7 lobbyists who are here. We look for those bills that impact our areas of responsibility, and we follow those bills through the legislative process. Currently, in my area of human resource, labor, workers' comp, and employment, there's over 400 bills that I'm following this legislative session that will impact those areas. In 2025, 856 bills passed both chambers. That was down from 1,000 in 2024. So it's kind of a quiet year in 2025. And then once these bills have passed, a few things can happen. And I want to point this out because in June, well, of those 856 bills, more than 400 of them passed in the last week of the session. So a lot happens in the last 5 days of the session. But you may become aware of bills that are impactful for your organization, right? Something that is dramatically important to you in the human resource field or in the nature of your business in transportation, tax, finance, technology. And it's an important bill for you. 3 things can happen. First, the governor and the legislature have until the end of the year to act on the bill. So the governor can either call bills from the legislature can send bills to the governor. Once that happens, the governor has 10 days then to sign or veto the bill. That can happen anytime between now and the end of the calendar year. So we had at the end of December a large number of bills that were acted on by the governor. So once a bill passes in June, doesn't mean it's become law. Another thing that can happen that's unique to New York State are chapter amendments. The governor can read a bill, decide this bill is, in general, I'm in favor of this bill, but it needs fixes. The leader of the assembly, the leader of the Senate could then get together with the governor and say, we will pass this bill. Governor says, I will sign this bill uh, upon the agreement that we make certain specific changes when the legislature reconvenes in January. That's important. Some of the bills we're going to talk about today were significantly impacted by chapter amendments. And just because a bill passes in June doesn't mean that's the final bill. So if you become aware of one of these bills that's important to you, you need to find out more about it. Call me at the Business Council. I'll put you in touch with the right lobbyist if it's not me, and we'll talk to you about chapter amendments, veto, signing, what might happen. Frequently, and I don't want to disparage our law firm partners, but sometimes they'll put out information that's not up to date and have incorrect effective dates and things like that. So if it's important to you, call me. Well, I'll let you know what's going on. Our fiscal year begins April 1st. That's our budget is due April 1st. That's the big event that happens in the Capitol. During this process, the governor has the most impact on legislation, so she frequently puts in the budget policy areas that are important to her. We had paid family leave in the budget under Governor Cuomo, increases to the minimum wage, things that don't sound like budget necessarily can be included in the budget in a policy area. We'll talk about last year and this year's budget and what's in there. The governor's budget this year is $260 billion. The last year before COVID, it was $175 billion. The state of Florida's budget is $117 billion, and they have more population than us. New York City has a $110 billion budget. So New York collects and spends a lot of money. There's a report out just today. We are the #1 state in the country for the amount of taxes collected per person, and we're #2 in the country amount spent per capita. So we collect and spend a lot of money in New York State, and it's an important time for us to get this budget done on time by April 1st. So by April 1st, we hope to have an on-time budget. Governor Cuomo, despite his other obvious faults, it was important to him to have on-time budgets. Governor Hochul, not so much. The budget last year was signed on May 9th, more than a month late. We'll see what happens this year. This budget is very low in policy initiatives. We're calling it an election year budget because everybody's up for election. It's pretty non-controversial other than its significant increase in spending from $254 to $260 billion. As I mentioned, 2026 is an election year. Everybody in the Assembly, everybody in the Senate, and Governor Hochul and the Lieutenant Governor are up for election this fall. There will be primaries in June. We have a very progressive legislature. Democrats control the Assembly by large amounts. They control the Senate by large amounts, and they control the governor, obviously. So we have one-party rule here. Within the Democratic Party, there's a very progressive wing called the Democratic Socialists of America, DSA candidates. Zoran Mamdani, the new mayor of New York City, is a socialist. The Democrats in New York are facing a lot of primaries from DSA candidates on the Democratic side. So in June, there will be primaries where a lot of these incumbent Democrats are going to be challenged from the left to make New York's legislature even more progressive. Governor Hochul is being primaried by her lieutenant governor, Delgado. He is primarying her from the left as well. So we're looking to see how all this influence from the more progressive wing of the party is going to steer this legislative session and this budget. How will these candidates, regular Democrats, let's call them, react to this DSA pressure in this legislative session? We think there will be a lot of the Governor Hochul will probably veer left. The legislature will veer left a little bit, at least until they get through the June primaries. That could impact us dramatically in legislation. So a lot to watch for. It sounds like it's going to be a very active year in Albany. Again, if you live outside of Albany, all we encourage you to do is vote, and be glad you don't live this on a day-to-day basis. So in 2025, here's an example of what Governor Hochul had in her budget in the labor and HR side that was an example of the type of policy that goes into the budget frequently. We had a pretty good budget year, we meaning business community, me meaning me, the labor HR side. It wasn't that bad. We had a win here in the first bullet, limiting liquidated damages for frequency of pay violations. As you know, or I hope you know by now, because it received a lot of press, Since 1894, it's been the law in New York State that we pay manual workers on a weekly basis. Anyone who works with their hands, working men, mechanics, it's not us typing on keyboards, but anyone who works with their hands has to be paid weekly, not biweekly. If you've been paying manual workers biweekly, you've been in violation of the labor law. That hasn't been a big problem for a long time. The fines aren't that significant. The Department of Labor enforcement activity wasn't that significant. But however, in 2019, we had a court case called the Vega decision in New York State that said late pay is wage theft. The penalty for wage theft is significant. It's you have to pay 100% of the liquidated damages. So you have a manual worker who makes $1,000 a week. You mistakenly paid them $2,000 a week. According to the Vega decision, you stole $1,000 from that employee. Now you paid him, right? At the end of the year, he got $52,000, but you only paid him 26 times instead of 52 times. According to the Vega decision, you owe him $26,000 times 6 years. They'll go back, times however many manual workers you have. The plaintiff's attorneys, as you can imagine, the Department of Labor is not interested in this. Nothing changed for them. But plaintiff's attorneys saw the opportunity to make a lot of money in this. And they did. More than 400 companies in New York were targeted. And they would come up to your place of business and say, I see you have manual workers. You've been paying them incorrectly. We added it up. It's $7 million. How much do you want to settle for? And as I said, we had 400 companies, more than 400 companies in New York State settle frequency of pay claims with plaintiffs' attorneys. Millions and millions and millions of dollars in payments were made. We couldn't get this fixed in the legislature. However, we got a partial fix, and that was what's in the budget here. An effective 5/9/25, and any pending actions are ones that are commenced after that. You would only be, if you mispaid this person biweekly, paid him incorrectly, you now only owe them the interest on the late money you paid. So you paid him $2,000 biweekly, you paid $1,000 late. You owe him, there's an interest calculation that they will go through to pay that. Hopefully, and I think it will, this will discourage plaintiffs' attorneys from coming and bringing these lawsuits and extorting settlements out of employer businesses. This is only for your first violation. If you're a repeat violator of the Pay Frequency Act, you will have to pay 100% liquidated damages. So if this is the first you're hearing this, and you have manual workers, you can apply for a waiver if you have 1,000 or more employees in the last 3 years. Just go to the DOL. You can Google this. They can tell you if you already have a waiver. And if you're certain not-for-profits, you're exempt from this as well. But if you have manual workers, make sure you're paying them weekly. They gave the commissioner wage theft enforcement powers, essentially giving the commissioner the powers of a sheriff. If you are guilty of wage theft, you didn't pay minimum wage, you didn't pay overtime correctly, you paid a manual worker biweekly, those are all wage theft. And the Department of Labor says you have a fine, you don't pay that fine or those penalties. The Commissioner of Labor cannot put a lien on your personal property. You meaning human resource professionals, you meaning the owner of the company. They can put a lien on your house, on your car, until those penalties are satisfied. Two important laws regarding child labor. One, dramatically increasing child labor penalties. If you employ minors seasonally or throughout the year, make sure you're complying with New York State's child labor laws because the penalties have gone up tenfold. So they are no longer nuisance penalties, they are significant. Youth working papers are going to be digitized by May 9th of 2027. So look for that. Unemployment insurance for strikers. New York is one of only 3 states that allows workers who go out on strike to collect unemployment benefits. It used to be a 7-week waiting period for that. It went down to 2 weeks now. It is a 1-week waiting period. People who go out on strike against your organization could be eligible for unemployment benefits from you during that period. We think this is illegal under federal law. There will be court cases and litigation to follow to try to clarify this. And then a couple of things in the workers' compensation field, not that significant, but I put them in as an example of what I think is going to be a big focus on the workers' compensation system. I'll talk more about it a little later. They're going to allow medical and surgical residents to treat workers' compensation payments, and you or your carrier can pay medical bills without accepting liability. These all became 5/9/25, became effective on 5/9/25 because that's when the budget was signed. Except the youth working papers, which they need 2 years to build up that system. Another big win for businesses this year was the unemployment insurance fund. As you know, when COVID started, we incurred a huge unemployment insurance expense. All 100% of the cost of the unemployment insurance system is paid for by employers. We had to borrow money from the federal government. We borrowed in excess of $13 billion to satisfy unemployment insurance claims during COVID, a time when we didn't close down, we were forced to close down. You might remember we've been paying this off in the form of higher UI taxes. We've been paying the highest UI taxes in the country as a way to get back to zero. In addition, we had interest assessment surcharges. You may have gotten a second bill in the summer, the last few summers, to pay this off. This was a burden on New York employers. We were able to convince the legislature to transfer $8 billion. We owe about $7 billion still. Well, we did at the end of 25. We convinced the legislature to move $8 billion into the UI fund to make the fund solvent, get rid of the interest assessment surcharges, and get our tax tables back to a place where they need to be. Part of that deal was a significant increase in the maximum weekly benefit for unemployment. The maximum weekly benefit is scheduled to go up every year and is linked to the state's average weekly wage. When the fund is in debt, that has to pause. And that's what happened in 2020. We paused at $504 a week. Now that the debt's been fulfilled, we jump to where it would have been in 2025. So on October 1st of 25, the maximum weekly benefit went up to $869. That's a big jump from 504. The fund's in good shape. It can handle it. However, this could have an impact on our UI costs as an employer. But trust me, this is way better than if we had not paid off this debt. On January 1st, 26, if we had not paid off our $7 billion debt, our federal portion, the FUTA portion of the unemployment tax, would have jumped dramatically by about $100 per employee. So this overall is a big win for employers in keeping our UI costs at least manageable. So what else happened in 25? It's new. I want to focus on a couple of things. New York State human rights law was amended. This took effect on December 5th. This expressly prohibits retaliation against employees who request a reasonable accommodation. There was some distinction between the ADA and the human rights law regarding this, really technical. I am sure that you out there have already assumed that retaliating against an employee who wanted a reasonable accommodation would have been unlawful, and you would have been correct. And it is now codified into New York State law. Disparate impact was codified into the New York State executive law. This is a reaction to the Trump administration sort of downplaying disparate impact discrimination. This became effective December 19th. And for those of you that aren't aware of disparate impact, this has, in a sense, always been kind of illegal. But if you have a practice that has an effect of being discriminatory, even though your intent was not to discriminate, that result would be discrimination and is unlawful. If your practice can be supported by legally sufficient justification, then okay. One of my favorite examples is we're going to hire a receptionist, and we put in the advertisement, high school degree required. Well, we know for a fact certain minority groups do not get high school degrees at the rate of other minorities or other non-minorities. So by merely having that policy in an advertisement, you're having the impact of discriminating against certain minority groups. You didn't intend to. So now you have to show, is a high school degree a legally sufficient justification? I bet I can find a lot of receptionists who have been very successful for a very long time who don't have high school degrees. So merely by putting that in our advertisement, we had a discriminatory effect. The Trump administration is trying to sort of remove that concept from federal law. New York State wanted to make sure it was codified into law, and it is. So just be aware of that as you're thinking about requirements for certain positions. Is it really legally sufficient, or is it having the impact of discriminating? If you are a bidder on competitive state procurement projects, you must certify that you have a written policy addressing gender-based violence in the workplace. You don't have to produce the policy, you just have to certify when you're doing the bidding that you have a policy. That became effective in November. Beginning April of 18th, 2026, we now have new restrictions on using consumer credit history for the purposes of discriminating against an applicant in employment. If you use credit checks as part of your screening process, you are now limited in doing that. Only those who are required by state or federal law can continue to do that. If you're checking credit for police officers, you can continue. If your employees need to be bonded under federal law, you can continue to use credit histories. If they have signatory authority over $10,000 or more, then they can continue to do these. If they have access to your computer system, if they're responsible for the security of your computer system, you can check these credit histories. But for instance, at the Business Council, we meet none of that requirement, so we could not be using credit histories for the purpose of making hiring decisions. So if you don't need to do them, don't do them. In fact, don't request them, right? It's requesting or using consumer credit histories. Let's get out of that business unless we're required by law or some other good practice to do so. Trapped at work. This is an important one and a good example of chapter amendments. This was passed in June. We were successful in getting some important chapter amendments made. The legislature felt that employers were trapping people at work by requiring them to work for a certain period of time to repay the employer for certain things, right? The most common one was tuition reimbursement. When we read this law originally, this would have prohibited employers from using promissory notes. So I'm going to help you pay for your degree. I'm going to pay for tuition and fees and books. In exchange, I expect you to work for 6 months, 12 months, 2 years, or if you don't, you have to repay some of that. That was considered by the legislature to be a promissory note and would be prohibited. We got that exception put into the chapter amendment language. We may seek repayment of tuition fees for a transferable degree, as long as it meets certain specific criteria. If you have tuition reimbursement programs and you require employees to stay with you and work for a certain period of time, you need to change your policy. You need to have a separate agreement, has to meet certain conditions in the law. This isn't in effect yet. This will take effect December 19, 2026. That was one of the changes in the chapter amendments. There is a problem with this that we're still trying to fix, and that is financial bonuses, relocation assistance, recruitment type bonuses, non-educational incentives are still prohibited from using promissory notes for repayment of that. Again, under some restrictions. So if you do use those types of, you use relocation assistance or incentives to come join hiring bonuses, you're going to need to talk to legal counsel about writing up an agreement that meets the conditions of the Trapped at Work Act. That's probably the most significant new one. If you are an organization that is required by OSHA to have first aid supplies readily available for the treatment of injured workers, then you must have an opioid antagonist in the workplace. Another good example of chapter amendment language that we were successfully able to get in. The original bill said every first aid kit would have to have an opioid antagonist. We got that changed to in the workplace. We also got some protection for employees and you that, if an employee passes out and you start jabbing him with Narcan, what's my liability, right? Administration of the antagonist shall be considered first aid under the public health law. So there's sort of that good Samaritan protection. And we made it so that the commissioner will promulgate regulations for this, the commissioner of labor. So they will work together to try to come up with rules and regulations. How many do I have to have per first aid kit or per employees? We have a lot of work to do on this bill. It's not effective till the end of the year, December 26th. But if you are one of these organizations, keep an eye on this. Additionally, if you're in the construction industry, you have construction workers working for you. There's a new way for them to qualify for paid family leave. As you know, they might not work 26 consecutive weeks for one employer. Now they only have to work 26 of the previous 39 weeks for any covered employer to become eligible for PFL benefits. So that would be a significant change to the PFL system for construction workers. Keep an eye on that. Your carrier will, I'm sure, be providing you with a lot of information on that. Also, another good example of chapter amendments as we clarified who'd be responsible for health insurance continuation and things like that. A couple of things that were vetoed by the governor that were significant in the workers' comp area. And again, I just lead these in because there will be the workers' compensation system, which is 100% paid for by employers, is a target of the legislature. They think that the insurance companies have made a lot of money. The state insurance fund has made money. There has been a reduction in the amount of claims paid to workers. Most of that is due to the COVID years when people didn't come to work. But the advocates, we think, are mistaken in thinking there's a lot of extra money in the system, and they're going to look to use it for things other than workers' compensation. So we will be, of those 480 bills I mentioned that I'll be watching this legislative session, there's at least 15 or 20 that are workers' compensation related. It'll be a big area that we'll be defending. Secure Choice Savings Program, you may have heard about this. It was passed by the legislature back in 2019. The state's going to get into the retirement business. And they have finally. It's taken a long time for the state to find a third-party administrator and a board, an investment board, but they have that now. If you are an employer with 10 or more employees in the previous year, you've been in business for more than 2 years, and you do not offer a qualified retirement savings plan, you have work to do. This is being administered by the New York State Department of Tax and Finance. You will be receiving communication from them. If you have this threshold of employees, you have a time where you have to go register with them. New York Secure Choice is where you go do that. It's the website. By registering, that means you will share all your payroll information with them. They will then reach out to your employees. They will mail something to your employees. Think about how this is going to work. They're going to mail something to your employees. Your employees will open it, read their mail like they always do, and they'll see that if they don't respond choose to opt out of the program within 30 days, then you, the employer, will withhold 3% of their pay and remit it to the state in their Roth IRA. Your employees, of course, won't do that. I'm being sarcastic. They will throw that letter away, not know that. You will withhold 3% and send it to the state. They will come in and say angry at you at what you've done to their paycheck. You'll explain that they have to call the state to get the money back. So I think overall, this is probably a good product for small employers who don't offer a retirement plan. There's no cost to this. There's no fiduciary responsibility on your part. But I think getting this up and running, we're going to run into some issues with our employees. So if you're one of these employers, you do not offer a qualified retirement savings plan, keep an eye out for this. Keep an eye on your employees. Make sure they respond to these letters they're going to get from Secure Choice from Tax and Finance. We have a new minimum wage this year. This is another area that will be getting a lot of attention. There is a demonstration outside my office at noon today for the people who want to raise the minimum wage. As you can see, for 1/1/27, that range, we don't have a number for that. That number will be determined by the Department of Financial Services and the Department of Labor as they do an analysis of the New York State economy, a review of the Consumer Price Index over the last few years. There's going to be a process. We don't know what 1/1/27's rate's going to be. There is a lot of pressure to raise that. The people who are rallying outside my office at noon today want 30 by 30, $30 an hour minimum wage by 2030. When it was the fight for 15, I used to joke that it was what's going to be next, the tussle for 20. They jumped right over 20. They want 30 by 30. They also want to get rid of the distinction between upstate and downstate minimum wage. They don't feel that there should be a distinction anymore. So we could be looking at a lot of pressure on politicians who are all up for election this year to increase the minimum wage significantly. We would see a big jump in 27, especially for upstate New York. So we're going to keep an eye on that. That will be one of the key battles that will be going on. The Business Council office, we have a sign out front. They know we oppose increases to the minimum wage. So we will have a lot of action when I go out to lunch today to try to make my way through the crowd. But watch for this. This is an area that's going to come. Now, the other thing you'll see on here is minimum salary levels for executive and administrative positions. As you know, to be exempt from employment overtime, exempt from overtime in New York State, you have to pass a test. We don't determine who's exempt and non-exempt. There's a test in the law. You have to pass 3 tests. You have to have the duties of an exempt or administrative or professional. You have to be paid as an exempt employee, meaning I can't reduce your weekly pay based on the amount or quality of work you do. And you have to be paid a minimum salary level. There is a federal minimum salary level, but New York has its own minimum salary level, and it's linked to the minimum wage. We try every year to decouple this. It doesn't happen. So right now in upstate New York, minimum wage is $16 an hour. The minimum salary level for executive and administrative exempt employees is $11.99 a week. That's $62,000 a year. So if you have an employee you think is exempt, but they're not paid $62,353 a year, they are not exempt. And now you have a problem because did they get overtime for time worked? Are you even keeping records for their hours worked? Are they getting uninterrupted meal breaks? Are they, all those things that we apply to non-exempt employees? Did you do those? If not, you engaged in wage theft, and we've talked about the penalties for wage theft. So make sure you're paying this minimum salary level for executive and administrative exemptions. Oddly, New York does not have a minimum salary level for professional exemptions, so you're allowed to pay the federal, which I think is still 683 a week, so significantly less. But keep an eye on the minimum wage. We're going to see a lot of activity this legislative session on that. We'll be keeping you informed. The governor's budget this year had very little in it, just two workers' compensation things, but I want to point them out. One is access to healthcare for injured workers. Right now, healthcare providers who treat workers' compensation patients have to be certified by the Workers' Compensation Board to do that. Only about 10% of providers are. So we hear stories all the time if someone's in Jamestown, New York, and they need a back specialist. They may not have one. They may have to drive a long way to get care, and we don't want that to happen either, but we don't know if this is the way to do it. The other is workers' compensation fraud. They're going to establish a fund, again, that we pay for, to track workers' compensation fraud. But this is not only employee fraud. This is employer fraud. You commit fraud in workers' compensation if you misclassify workers as independent contractors when they are, in fact, employees. Again, we don't determine who's an independent contractor and who's an employee. The law does. We have a lot of employers who misclassify workers as independent contractors to avoid paying workers' compensation and UI taxes and all these other things we want to avoid, paid family leave, right? They are misclassified workers. This is a huge area of exposure for New York employers. This fraud emphasis will focus on employers misclassifying workers. So let's get our classifications done correctly so we're not a target of this fraud should this become part of the governor's budget. Some other key legislation. I think the most important one we're going to be battling is a huge increase to short-term disability benefits. As you know, New York is one of only 5 states that require employers to replace the income to individuals who become injured or sick away from work, right? If you go skydiving and hurt yourself, if you get drunk and crash your motorcycle, I'm responsible for replacing some of your income. Currently, that's only 50% of your average weekly wage, up to a maximum of $170 a week. There is a push to dramatically increase that, to make it PFL type benefit. The problem is disability is 26 weeks, right? Every 52 weeks. Paid family leave is 12 weeks every 52 weeks. So increasing this benefit dramatically would have a dramatic impact, I think, on utilization. We'd see a lot more people. I'm from Elmira, New York. I always like to point out that on the first day of hunting season, there would be a lot of back injuries that flare up. You know, people need a couple weeks. If they're willing to do that for $170 max, how much are they willing to do it for significantly more? It's an interesting program, week 1 through 12 in this bill that's on the screen here. When fully implemented, and it'll be implemented in steps like PFL was, but when fully implemented, they would get 2/3 of their average weekly wage to 2/3 of the state's average weekly wage. In today's dollars, that's $1,200 a week. So we're going from $170 a week max to $1,200 a week when fully implemented. And in fact, when this is fully implemented in 4 or 5 years, we're probably talking a $1,500 a week benefit. So significant increase. Week 13 through 26, it drops to 30% of their average weekly wage to 30% of the state's average weekly wage, which the commissioner can change these numbers anytime she wants. That's in today's dollars about $550 a week, which sounds like more like a reasonable benefit. I don't know how insurance carriers would even price this product, right? Are we going to see a lot of miraculous recoveries from week 12 to week 13 when my benefit is cut, by 2/3? It seems like a difficult price. This will have the cost for employees will go up. It's been $170 max since 1989. Employees have paid 60 cents a week max since 1954. That would go up to $2.20 a week. Plus, once it's fully implemented, it'd be like a 60-40 type split, though it's not really. Employers would be paying significantly more. Bottom line, employers would be paying significantly more for their DBL product than they are paying now per employee. So this would have a huge impact on cost to employers, a huge impact on utilization, I'm sure, as we see employees use 26 weeks out of every 52 weeks for disability. There are other features in this that are concerning, 6 weeks specifically for the stillbirth of a child. This can be taken intermittently in full day increments. I'm no math genius, but I think 26 weeks times 5 days is like 130 days intermittently every year. wrap your heads around that. If you have someone who's diagnosed with a disability, say diabetes. I have diabetes. I'm disabled under the New York State disability law. And I can't make it to work today um, because of the effects of my diabetes, 130 unscheduled absences. Healthcare continuation and job reinstatement. This would be job protected leave. Disability is not job protected now. You can replace anyone who goes out on disability. Don't do it. So you can imagine with job protection, health insurance continuation, intermittent leave, and this much more significant weekly benefit, the impact it would have on just staffing our businesses. So we are looking to oppose this for a number of reasons, the obvious reasons. I picked some example plans here, just to show what I think the emphasis is going to be. Prohibiting non-compete agreements and other restrictive covenants on employees, mandatory arbitration, things like that. If you use that, those are going to be targeted by the legislature. The Temp Act, this is the belief, our legislature believes that the that the Trump administration is going to just get rid of OSHA. So they want to Trump-proof New York by putting more employee protections in the law, one of being the Temp Act that would require us to protect workers exposed to heat or cold. The Empire Act, this is also another wage theft bill that's significant. The legislature thinks that you employers are so egregious in stealing wages that the Department of Labor can't keep up, right? There's so much wage theft going on, the Department of Labor can't do it themselves. So the Empire Act will deputize pretty much anyone to come into your place of business and act on behalf of the Department of Labor to find wage and hour violations. I hear you paid Bob's overtime incorrectly. I want to see all your pay records to see if this is something you do on a regular basis. And then you'll be like, who are you? Oh, I'm with a union, or I'm with an attorney who does this. Oh, and by the way, I get 60% of the whatever the fine and the penalty is. So there's an incentive for me to do this. This is actually passed the legislature and was vetoed by Governor Cuomo, but is a priority of organized labor and will be back again this session. Use of wage boards. In New York, the Commissioner of Labor has the ability to form a wage board. The legislature appoints, the Senate appoints a person, the Assembly appoints a person, the governor appoints a person. The three-member board can then go and determine whether the wages are adequate for a particular industry. We saw this in fast food. We had a fast food wage board. They came up with a fast food minimum wage. It's into law. This is a way for employee protections to be increased without going through the legislature. But it's limited to wages. This bill would expand that to go to any industry and to look at any benefits and working conditions. If you're in healthcare, you'll be the number one target on the list if this is passed. This is an unelected wage board that would be able to set the terms and conditions of employment for your industry. California has this. They used it for fast food at the beginning, and it's been a disaster for fast food in California. This bill would get rid of the upstate, downstate difference in minimum wage. By the way, you'll see some familiar names on here. Senator Ramos is the chair of the Senate Labor Committee, and Assemblyman Bronson from the Rochester area is the chair of the Assembly Labor Committee. They are often the leaders on these bills. And then this other bill, this final one on the page here, mandatory employer disclosures regarding compensation and benefits. You remember pay transparency. We have to put a good faith minimum and maximum into our pay structure. This would require you to put your health insurance payments, the deductibles of the health insurance, the co-pays of the health insurance, any stock options you offer, any bonus plan you offer, all that would have to be in your employment advertising. We are opposing that, but there is a momentum behind this that is concerning to me. Then I want to touch on some things really super quick that are kind of old news now. These took effect in 2025 as a result of the 24 session. Don't apply to everybody, so I just want to touch on them quickly. If you have a warehouse of 100 or more employees, as you know, you now have you have to adopt a injury reduction program. The Department of Labor has a website with templates you can use for that. That's effective June 1st. If you have 10 or more retail employees, you have to have a safety plan adopted and a training program adopted. By June 2nd of this past year, those again, all model programs are available on the DOL website. If you have more than 500 retail employees in New York State, you have to have panic buttons beginning January 1st and 27. I'm sure you've been contacted by panic button vendors by now if you are one of those. Stress-related workers' compensation claims are now easier to prevail. That took effect in June as well. Anyone who experiences stress greater than the normal work environment, as PTSD, acute stress disorder, or major depressive disorder, now has an easier path to getting that claim approved. Jury duty, some minor changes. One, it's a criminal contempt of court to interfere with a person's ability to serve on a jury. And if you're an employer who employs 10 or more employees, you can't withhold the first $72 of their daily wages during the first 3 days of jury duty. That used to be $40. So go check your handbook, make sure you have the up-to-date language in there as well. By the way, all these slides will be available to anybody who wants them. COVID paid sick leave ended July 31st, 2025. If COVID is like any other respiratory disease, it's like having the flu. Treat your COVID employees any way you want. You're not obligated to comply with COVID paid sick leave. Clean Slate Act, this went into effect at the end of 24. This will have certain criminal records automatically sealed once they've completed their sentences and do not reoffend. Misdemeanors after 3 such years, felonies after 8 such years. Some crimes will never be sealed. These aren't expunged. They're just hidden from you if you don't have a legitimate need to use them. The problem is that courts have until 11/16/27 to seal these records. They have not all been sealed. So if you're checking criminal background checks now and you get a criminal record, you may not be eligible to see that. The law is in effect now. The courts don't have them all sealed. Be careful if you're one of these organizations that checks criminal backgrounds and you aren't required to by law. You're just doing it for your own interest. If the business council was doing criminal background checks and we received a record from someone who it should have been sealed, we cannot use that for the purposes of determining whether they are eligible for employment. There have been numerous immigration changes for those eligible to work in the United States. If you have a large population of CHNV, that's Cuban, Haitian, Nicaraguan, and Venezuelans, their temporary protected status has ended. Same for Somalis. More recently, you need EADs or employment authorization documents. You need to make sure you have the proper I-9 forms for these people. Many of them are no longer eligible to work in the United States or even remain in the United States. ICE raids have been all you see on the news these days. Those actual physical raids are nothing compared to the amount of ICE doing I-9 audits. If you have any non-native born Americans working for you, you need to have I-9s in shape. They've never been more important than they are now. Make sure your employment authorization documents are up to date. And that's all I have. I'll leave my contact information up here. You're welcome to reach out and contact me. I tried to leave some time for questions. Eric was going to moderate those for me. But if you don't want to ask questions now and you have a specific circumstance you want to talk about, my contact information is on here. I'd be glad to answer any questions.